My name is Zachary Fowler. I'm a partner here at McGinley and co-chair of the Healthcare Defense Group. And in that role, I represent medical providers, doctors, nurses, physician assistants, specialists, as well as facilities like hospitals and long-term care facilities. And I represent them in court and at trial in front of juries and judges throughout the Commonwealth of Pennsylvania. And what I want to talk to everyone about today is arbitration clauses and whether it makes sense for your facility to have these in contracts. And essentially, when a resident comes in wanting to establish residency at a long-term care facility, you can have them sign a contract that includes an arbitration clause. So what does that mean? An arbitration clause basically waives that resident's right to a jury trial. And instead, if there was a claim that arose, they would have to bring it in front of an arbitrator. And that's usually a retired judge or a lawyer in the community. There are both pros and cons to arbitrations. The pro, of course, is it's more cost efficient for the facility. Typically, you get a quicker resolution to the claim. You might spend more money in front of a jury trial working the case up because you have to bring experts in live to testify in defense of the facility. And in arbitrations, oftentimes you can just submit those experts on report. And then, of course, the legal fees are usually considerably less in arbitrations. And again, you get a quicker resolution. The cons, of course, are that arbitrators are hired by both the plaintiff and the defense bar. So they want to keep both sides happy. And oftentimes that means that they will give an award even when the defense is really good for the facility. And the good news is they don't typically give a runaway award like a jury may, but they typically don't give an outright defense award. So sometimes it's better if you have a really strong defense to want to be in court and want to be before a jury, because a jury doesn't have that same loyalty and they may just give an outright defense verdict. So basically, you have to evaluate your risk tolerance, and we're here and happy to discuss those with you to see what fits your objectives. At a minimum, if you don't want an arbitration clause in a resident contract, what I would suggest is to have a choice of venue provision in the contract. And there's a new case in the Superior Court of Pennsylvania called Summerlot. It's a very important case to the defense bar, which says that the courts will honor a choice of venue. So you can pick any venue that you want the claim to be brought in. And typically what you want to do is, at a minimum, pick a county and a venue that is defense friendly, like here in Lehigh County. So at a minimum, even if you aren't inclined to have an arbitration clause, really important to have a selection of venue clause. Of course, we're happy to answer any questions and happy to help in any way, because these issues are very complicated and often need the eyes of an attorney.